Well, hello, everybody. I am attorney Michael Eline. I am a California and Texas attorney. My background is in appellate law, and that's how I got my start. I used to be an ex for the California Court of Appeal. Hopefully, you just heard what I said. I had a little bit of feedback going on there. Anyways, my name is California and Texas attorney Michael Eline. My background is in appellate law. I got my start as a judicial extern at the California Court of Appeal, and prior to that, I worked as a paralegal and law clerk doing appeals. So I have a little bit of experience at this. Done quite a few appeals in my life and ended up doing criminal defense and got into personal injury law. But my love is the Second Amendment and First Amendment. And that's what brought me to you today. So the first thing I want to say is thank you, everybody, for showing up in the sidebar. Thank you, Let's OTVO, for coming. Thanks, Kurt Bronson. Give me a bunch of OTVOs for Chille. And look, I know a lot of people make their living off of trash talking Chille, and they get all their millions of views and likes from saying bad things about Chille and delete laws. So basically, from my perspective, he's created a whole industry of bottom feeders who are basically living off of him in order to pay their bills if their channel is monetized. I have my own firm and I do this voluntarily. So just a little disclaimer, I don't get any money for doing this. This is voluntary work. It's part of what I do because I believe in the Constitution and the Bill of Rights. And I believe that if you represent unpopular people, you should get an award for that, not be destroyed by people. And I think if you look back at history, you'll see that a lot of our founding fathers, one of them even represented the redcoats who gunned down a bunch of American citizens. And he was also ostracized much the same way as I am being now. However, I'm not going to let it silence me, but I do want to preface this with sort of saying the pendulum seems to be swinging. It used to be that the left supported unalienable constitutional rights, and now we see a pendulum swinging where the First Amendment apparently hamstrings the government. And if an administrator disagrees with you, they immediately try to classify everything you say as hate speech. And that's the new end run around the First Amendment. So I think we all need to be very, very concerned about the First Amendment. And the fact that we don't have a lot of law about the press and filming police and stuff like that tells you a lot about what's going on. There never needed to be a law in order to film or be a journalist. And all of you should know that you don't need a college degree or to go to some government approved school to be a journalist or to be a reporter. So that being said, I want to get into this with you a little bit. First, I want to thank everyone for showing up again. We've got, so Greg B, I appreciate you showing up, Greg B. And I appreciate all of the stuff that people are saying. Apparently, they've heard a lot of stuff from people who don't like Chille, and they're using that as their basis to say that his appellate brief is no good or whatever. And I understand that. But I also want you to understand that opinions are like assholes and everyone's got one. And what really matters is the judge or panel of judges that hears the case. And that's just how it works. If you got a bad judge or what people consider to be a bad judge and you support the Constitution, you're going to lose. And of course, this particular case is in the Ninth Circuit, and the Seminal Case that helps us is in the First Circuit. So that's the Glik case. And we'll get into that a little bit. But I want to make sure that you all understand what's going on. And yeah, that's right. Torture cuffs are always torture. I love that. Yeah, Gloria. Thank you. Thank you, everybody, for showing up, by the way. I don't really have an axe to grind with anybody. It's just interesting how you see these non-attorneys, they'll cite a big section of law and say that you're in violation, or they'll cite a case to say that this stands for the proposition that supports their side. But then when you read their cases, it's complete nonsense. For example, I saw a video today by someone who hates Chille saying that I violated the UCMJ because in one of my videos, I created a parody of myself wearing my camis from the Marines. And it says right in that code section that the only way that section applies is if you confusingly convince someone you're an active duty service member. And of course, everybody knows that I'm not active duty. I've been out for years. So I just want you guys to understand, don't believe anything these guys say because they don't know the law. They don't know what they're talking about. At least Chille's made a good faith effort to try and learn the law and to try and get the legal training that he needs. And so because of that, I just wanted to sort of just like lay that initial foundation. And now what we're going to do is we're going to go ahead and take a look at his appellate brief. And so basically the way this is working out, guys, is you guys all know the story, right? He was in a private parking lot. He pulls up, he sees a woman who is apparently getting cited by a cop. About 10 feet away, he starts talking with the woman. He tells the cop that he's a member of the press. And of course, his detractors say, well, you're not a member of the press unless you have a government approved license. And that's a problem for me because if you really trust the government, that's a problem for me too, because we've seen that they completely were dishonest with us about this government shutdown that we just had, what, a year and a half or 2 years ago, where they basically bankrupted a lot of businesses and forced school children to take these shots. And now you see that one of the main detractors from CNN, who said that people who don't believe in taking these injections are conspiracy theorists and whack jobs. I think his name is it Cuomo? Is now taking ivermectin, which is what they gave out in third world countries. And it works perfectly well to cure things like cancer, as well as a lot of other problems. And apparently it worked for me very well to stop my COVID in less than 3 days, and as well as my kids. Luckily, my wife's from El Salvador, so we had access to it, while our own government prevented us from having access to it, forced us to take the mRNA or lose your job if you were in the military, that kind of stuff. So, you guys need to understand that it's not just a black and white situation here. We have politicians who receive massive amounts of money from people who just look at us as a way to make a living, and they don't look at us as humans. I look at us all as humans. My mother-in-law died from thrombosis 3 days after her shot. And we know that pharma, along with the government, tried to bury that data for over 50 years. Luckily, we had help from people like Tom Fitton to get that data. But even then, big media and the press buried all that stuff. So let's get into it. Let's talk a little bit about what's going on here with Chille. So in Chille's brief, it basically breaks down that he was a member of the press, and he testified that, he's known across the world, and that within 10 seconds of filming of the incident, he identified himself as a member of the press. Now, whether or not you want to believe that he was a member of the press or not is kind of irrelevant, because that's not what matters. What matters is that the First Amendment says that he has the right to free speech and press. And the First Amendment doesn't say you have to have a degree from some leftist learning institution to be a member of the press. So let's just get that straight, first of all. So he's identified himself as a member of the media. He said that he had over 353,000 subscribers. I think he's got like over 500,000 now. So it looks like he's become more popular since he got locked away. So I don't want to get too much into it, because we already kind of know the facts, but we know that at some point he was holding 2 cell phones. The cop knew that he wasn't a threat, but the cop decided to, in court, say that there's a 21-foot rule and that Chille was in the danger zone, threatening officer safety. So the officer goes ahead and dismisses the woman that he pulled over and focuses attention on Chille. And Chille's like, I'm a member of the press. I'm not doing anything wrong. The cop says, back up. Chille starts to back up, doesn't back up fast enough, apparently. So then he says, okay, I need you to walk over to my car, which Chille does. But then the guy tries to put his hands on Chille, and Chille doesn't like that because he doesn't see any reason for the officer to put his hands on him. He's already in compliance, walking towards the patrol car. Now we know what happened as a result of that. We know that Chille was arrested, I believe falsely arrested. And we know that he angered the trial court, and the trial court was going to hold him in contempt. Many people believe that rather than hold him in contempt, she just threw the book at him to teach him a lesson. And a lot of people don't like that. I know that there's a big problem with people apparently contacting the court, trying to petition the government. And so we saw a big pushback by many people on the internet saying that somehow that is harassment and that Chille can somehow be charged with some kind of crime that's going to get him 5 years. I don't know that to be true. Based upon the evidence that I've seen so far, I don't see that happening. Now, also, just at the outset, I want to tell you guys that Chille is not being segregated from the regular population. I believe that Chille is just listening to the advice of counsel and trying to just not say anything and just let the appeal play itself out. And I believe that he's in the process of studying so he can become a lawyer. So you guys know that. It's kind of important because there's so much misinformation and disinformation, and he doesn't really have anybody to stand up for him. So I'm just trying to explain what the facts are, and you can go ahead and decide how you want to handle that, or if you want to believe it or not. So the situation that we're dealing with right now is that Officer Bork testified at trial that Chille was at least 10 feet away from him when he first observed him filming. And of course, the officer also admitted that he was not in fear of Chille and that Chille was not a threat to him. But yet the reasoning of the court appears to be that Chille was within 21 feet and somehow this unwritten law placed the officer in danger. So the officer's response to being placed in danger for Chille being too close to him was to bring himself closer to Chille and bring himself further in the so-called zone of danger, even though he testified he knew that Chille wasn't a threat. We also know that the officer was already releasing or had released this person, and that he did in fact release the person before he came up to Chille and tried to put him in custody. So the woman was already gone. The traffic stop was over. She was allowed to leave. And now the officer had focused his attention on Chille. And so that's kind of important. And we'll get into that in a second here about why that's important. Now, we did see one appellate lawyer from Irvine argue that this case shouldn't be compared to the George Floyd case. And, you know, I kind of disagree, because after looking at the brief, because initially, I got to tell you, when I first saw his video, I was like, oh man, this is bad for Chille. But, you know, because Chille didn't get killed, or, you know, Chille, there wasn't a murder or anything like that. Well, that makes it totally different. But actually, if you read the appellate brief, what it's really saying is that we've already got an established pattern of people filming people getting arrested. And the people who were filming George Floyd getting murdered were actually within the 10-foot zone. And so the appellate attorney was just simply arguing, like, can you imagine how that would have gone down? Probably not too well. I mean, could you imagine? I can't imagine it either. So he's simply asking, would the federal prosecutors in Minnesota have gone after the people filming and tried to suppress that evidence? And so, well, yeah, nobody died here, but still, you know, he's filming a traffic stop and he's got the right to do it. And we're going to get into that in a second as well. Now, we also discussed the 21-foot rule in one of my other videos. It's not a rule. It is a sort of a policy or an idea that is designed to keep police from getting prosecuted for murder if they shoot someone within the 21-foot area. That's what it's really about. As long as you shoot someone who's coming at you within 21 feet, there's a high probability that cop's not going to get charged with murder. It has nothing to really do with any law. It should never have been used as a basis to prosecute Chille. But apparently, based on my view of the court and the trial, that seems what the whole case was based on, even though the officer admitted that Chille wasn't a threat. So, by the way, give me comments if you disagree with me or there's anything else you want me to talk about. So I'm going to get into some other things here. Basically, his attorney is arguing that Officer Bork grabbed Chille and violated his 4th and 14th Amendment rights. And he's saying that if Chille had captured police brutality towards the motorist and it was covered on the mainstream press, that Chille would be named a hero. And now give me a bunch of ones if you agree with that, because I do agree with that. I agree that Chille would have been branded a hero if that person had been getting beaten or whatever. But in this case, based on the video, it looks like this cop was hitting on this girl and she was giggling and having a good time, and that Chille kind of messed that up for him. So that's what a lot of people are saying, that, we know that goes on all the time. He didn't even give her a ticket. I mean, come on, guys. Something was going on here. No registration, no front plates. Think about it. That's what a lot of people are saying. So we get into the brief. By the way, this is just the opening brief on appeal. We're still waiting for the reply brief, or for the opposition brief, and then, of course, the reply brief that's going to come down. And this is all Ninth Circuit. So this is the same circuit that I would be dealing with if I was handling an appeal in California. And it never seemed to the defense counsel, the prosecutor, or the trial court, according to the brief, that the imaginary 21-foot rule would have caused the prosecution of bystanders filming during the murder of George Floyd. And that's what that was really about. So just understand that when someone just comes and starts trashing an appellate lawyer because they want to get views or likes, it doesn't mean that they're right. And so, I'm not necessarily a fan of Chille's appellate lawyer. I don't even know him, never met him. He walked by me when I was trying to appear in court on Chille's behalf so I could sign a document that I was unable to sign, attesting to Chille's character, and just blew right past me. So, I'm not biased in favor of this guy at all. Okay. Don't think that I carry water for his lawyer. I don't. But I think that is a sound argument. I think that is a decent argument. And now, whether or not it's going to pass judicial muster at the Ninth Circuit, who knows? Who knows? But what ended up happening here is the way an appellate brief works is you're going to do your statement of facts, like an introduction, statement of facts, and you're going to get into your arguments. So the first argument is that Chille's convictions have to be reversed because of the First Amendment. And I believe this is actually pretty good. He's citing several cases, but the big one is Glik. And Glik is, again, it's a first district case. There really isn't anything that's on point in the Ninth Circuit, unfortunately, but it is still persuasive authority. It's not a DPub. I know that Merb likes to use depublished cases, but depublished or unpublished cases, if you want to split hairs, if you use those, you're probably going to end up getting a bar complaint or have the judge sanction you. Very rarely will a DPub ever be persuasive authority. It's almost non-existent, especially if it's not in the right district. But in this case, we have a case that unfortunately is first district because there isn't anything else that we can find. But basically, he goes into Chief Justice Berger talking about the free press being a guarantee. He talks about the constitutional guarantee of a free press to create a fourth institution outside of the government is an additional check on the three official branches. And that's kind of something that's really important to me because, we see that social media and big tech has basically formed an alliance with the CIA and the FBI to spy on people. So, their fact check labels are suspect. We know everything that they tell you is suspect because they're carrying water for politicians who get a lot of money from big corporations like BlackRock or Pfizer. So I don't find them to be in any way, shape, or form trustworthy. So anything I get from an independent journalist, I'm going to find to be the most persuasive. Give me a bunch of ones if you think that independent journalists are much more persuasive than someone who works for CNN or carries water for pharma in the for-profit media. Give me a bunch of ones if you think that. Give me a bunch of twos if you trust politicians and people receiving money from huge corporations, if you believe that. So let's get into it here. So basically, our founders were very clear about the distinction between the branches of government, the First Amendment, and they deliberately created an internally competitive system, which we know that at least one Supreme Court justice apparently doesn't like. She says that the First Amendment hamstrings the government. But of course, when you can't even define the difference between a male and female, and you know that the DEI supporting lobby made sure that you got that slot, you're definitely going to be on their team, right? Give me a bunch of ones if you agree with that. Many people believe what I'm saying is true, that the whole system is corrupt. Now, and driven by corporations. So in this case, the appellate attorney said that, did Mr. DeCastro have a First Amendment right as a member of the public or press to film the police? And of course, we know that he did. And he goes in to cite the Glik case, the constitutional right to film public officials. So although I believe that the Glik case is a persuasive case, is a persuasive case, I still have to think that ineffective assistance of counsel is probably a pretty solid argument here, because Chille's body cam footage that he took was never even entered into evidence. And we also know that there weren't any real good objections made that would have supported a strong appeal. Now, typically for me, my understanding of ineffective assistance counsel claims, at least in California state cases, typically those are brought as motions for new trial with the actual court. Now, in this case, we have a problem because the court was also the jury. And of course, people have correctly pointed out that Chille apparently waived his right to a trial by jury, because he did face more than 6 months because of these two charges combined, could have had him face a year. Again, I'm not a Nevada lawyer. I practice law in Texas and California. I just happen to represent Chille in claims that are not in Nevada. And so I am trying to help you guys understand the dilemma that we're facing here. There's a lot of misinformation and disinformation by people chasing clicks and views instead of trying to be fair, in my opinion. Now, the constitutional right to film public officials has been firmly established by the courts in Glik versus Cunnife. And that's 655 F 3rd 78. It's a 2011 case from the Court of Appeals for the First Circuit. And I have conferred with Alan Beck, who I believe is one of the preeminent appellate attorneys in the United States. And he agrees that Glik is a terrific case for Chille. And basically, in Glik, Mr. Glik was arrested for using a cell phone to film several police officers arresting a young man on the Boston Common. He was arrested in violation of Massachusetts wire statutes and disturbing the peace. So again, I've tried to help you guys understand, when you cite a case, you don't just cite it for the proposition it stands for. You look at the facts of the case and you see if they're comparable to your case. So obviously here, there's not a wiretapping statute issue, but there is a disturbing the peace or interfering with a cop issue. So that tells me that it's pretty on point. It's a pretty solid case. Now, in this case, he was arrested and they tried to say that he aided in the escape of a prisoner. And of course, the case was ultimately dismissed in the criminal court, but he had a good judge and probably had a jury, that was going to hear it. And so in this case, this guy was successful and got that thrown out. He ended up suing for violations of the First and Fourth Amendment. And of course, the cops claimed qualified immunity like they always do, right, guys? That's what they do. And they lost. And ultimately, he went ahead because he overheard bystanders commenting about this guy being arrested. He thought the cops were using excessive force, and he began filming about 10 feet away, just like Chille. So that's not a bad argument. I'm just telling you, as an appellate lawyer. Yes, I'm going to be honest, guys. Okay, listen, I saw typos. I saw grammatical errors. That's going to happen. Probably for me, that would have probably been my second draft. I probably would have done a third that was a little bit better. But you don't know what this guy's calendar is like. This was a last minute appeal that he took on, and Chille really needed him. And I think the guy stepped up for him and went the extra mile to help him with the limited time that he had to get the best possible work product out that he could. That's my honest opinion. And look, you guys got to know me by now. I'll talk trash on people if I think they're full of crap, but as a general rule, I'm not an armchair general. And so I'm not going to sit there and trash talk him or his detractors, other than to say that I feel his detractors weren't quite genuine, weren't quite honest about Chille's chances and the arguments that his lawyer made. But that's just me. Now, in this case, the Supreme Court has observed many times that the First Amendment goes beyond protection of the press and self-expression of individuals to prohibit the government from limiting the stock of information from which the public may draw. And so I'm going to just really quick, I want to show you this. If there's a way I can blow this bad chicken up, I will. Here we go. Yes, this is great. So I just want you guys to read this. The Supreme Court has observed that the First Amendment goes beyond protection of the press and self-expression of individuals to prohibit the government from limiting the stock of information from which the public may draw. And I know that Chille's detractors are going to immediately come out and say, yeah, but Chille, you know, he was interfering. He was interfering. He was talking to the person in the car. He was interfering. And so he wasn't engaged in a First Amendment protected activity. He should have been arrested and thrown in jail. Well, guys, I'm sorry to tell you, but the Glik case and many other cases, by the way, don't support that proposition. He was not a threat to the officer. That was admitted on the record. The 21-foot rule is not a rule. It's simply a standard that they teach you at some police academies and some district attorneys who do tailgate safety meetings. So the cops will know that if someone's coming at them within 21 feet, it's okay to shoot them center mass. So that's what that rule is really about. I just want you guys to understand what's going on. Now, the Supreme Court has already ruled that, you know, the government shouldn't be doing this stuff, shouldn't be trying to interfere, stop people from filming. We know cops don't like being filmed. That's pretty common. We know that the Constitution protects the right to receive ideas, right? And that would be filming so people can get those ideas. And there is an undoubted right to gather news from any source by any means within the law. And that is also a U.S. Supreme Court case, Hutchins versus KQED Inc. And that's quoting Brandsburg v. Hayes, 408 U.S. 665-681-82. And then we have Glik versus Cunniffe. And that is, I think that's a pretty solid case for us guys, for Chille, for our side, which is the side of natural law, Bill of Rights, freedom. And of course, you know, you may disagree with the way Chille approaches things. I don't always agree with the way he approaches everything, but I do agree with his goal, which is to hold the government accountable. And so I will carry water for that concept. And hopefully give me a bunch of ones if you will too. And if you think that everybody out there is perfect and is always going to make the right decision, then, you know, I can't help you. But in this particular case, guys, we had Chille standing at least 10 feet away. We had him backing up, just didn't back up fast enough for the cop. And so the cop decided to put him in torture cuffs, put him in the dungeon, and, you know, take away his money. That's what ultimately happened. Thanks, James Hill, for getting a membership for Team DLZ. Five memberships for Team DLZ clips. And that's what I was hoping, guys, is that, look, you know, I volunteer my time to come on here. I don't get anything out of this other than just the satisfaction of knowing that maybe I can help keep one of you guys out of jail and educate you. And if you want to come over to my channel, it's down there at the bottom, Michael Eline. I'm going to start doing a course on how to become a lawyer without law school. And I'm serious. I want you guys to learn the law so you don't get arrested and you're more educated when you deal with your detractors, especially the police or anyone else. So let's get into this. And look, I know I'm long-winded. I'm a lawyer, so don't get too mad at me. I want to lay a proper foundation anytime I talk to people. So I just want to read this to you really quick. Moreover, the court has noted that freedom of expression has been of particular significance with respect to the government because lilt is here that the state has a special incentive to repress opposition and often wields more effective power of suppression. And of course, we saw that with the last election where, you know, now we know from the Twitter files that the Biden administration and its FBI and CIA were actively suppressing the Hunter Biden laptop story and encouraging Twitter and Facebook and all these other companies to ban your social media accounts. And we saw social media accounts with millions of followers deleted completely forever because they didn't go along with the official censorship narrative that the laptop was Russian disinformation. We know that was a lie now, and they knew that it was not Russian disinformation. And we know at least, I think it was 20% of Democrats say they would have never voted for Biden had they believed and known that the laptop story was true. So why do I say this? It's not to be political. It's to show you that the government works in collusion with social media and the press and large corporations to suppress and repress opposition, and often wields more suppressive power than anybody. And so, and that's First National Bank, 435 US at 777. Because whether or not Chille wins or loses his appeal, that's not what matters. What matters is that you guys know what the law is, because ultimately you're the jury, not the whoever's going to be on his panel in the ninth. In this case, it's going to be, I believe, 3 justices. Now, this is particularly true of law enforcement officials. In other words, being able to suppress people, because they're granted substantial discretion, and that may be misused to deprive individuals of their liberties. And that's the Gentile case versus the State Bar of Nevada. And by the way, so let me tell you a little bit about Gentile. This guy's kind of like a Chille DeCastro. He's an aspiring lawyer. I think he's studying to be a lawyer, or he just passed the bar. And so he's just doing what I would do. He's busting out his camera and filming. Now, I wouldn't have walked up to a cop and called him a little doggy or any of that stuff. But guess what? Chille had the right to do that. And give me a bunch of ones if you believe he would not have been put in torture cuffs if he had not said that. Because I think that's what this whole case hinges on. And I'm hoping he'll get some traditional old school liberal justices, like the old school ones, not the modern leftist ones who think that the Constitution hamstrings the government, but the old school ones who used to hate people like Warren Burger, right? The old school ones who believed in natural healing, the old school liberals that didn't support the pharma lobby. Remember them back in the 60s? Like those ones. Yeah. I think that if Chille got one of those guys, this would be a slam dunk case. Give me a bunch of ones if you think so too. Now, I'm going to keep on going. So basically, they have basically unfettered discretion to violate your rights. And so this aspiring lawyer went ahead and faced off with these guys because he wanted to ensure that the public's right to gather information about their official could aid in the uncovering of abuses. And that's core to the First Amendment, and that's 1034-35 of the Gentile versus State Bar case. So ultimately, it appears as though Gentile had some problems with the State Bar for standing up for the Constitution. And we'll go over the Gentile brief in a minute. Now, let me just share something with you guys. I have at 7 on my channel, I'm doing a show with Max Bonilla. He is a young 19-year-old genius, a historian, and we're going to talk about some research that he uncovered that actually shows that Bill Clinton allowed illegals to vote in federal elections under certain cases, certain situations. And we're going to talk about that just because it's something that was suppressed by the press. And I like to expose things that the for-profit media that's paid off by large billion-dollar corporations won't cover. You know more about your press and who your enemies are by what they won't say than what they will say. And so we're going to talk about that. So I will not be here all night, but I do have time. I've got about an hour solid that I can spend with y'all. And I do want to share this stuff with you because I just feel really bad that so many people are, because of hatred for Chille the person, are ignoring the two false arrests, and they're ignoring what's going on here. I mean, this is crazy. This is like the Christians being thrown into the Colosseum and fed to the lions. It's just like this feeding frenzy for likes and views. And they don't really understand that this could be their crazy uncle. This could be one of their cousins. This could be their grandfather. This could be their brother who's a constitutionalist who sees the corruption in this world and is trying to make a difference. Non-violent, non-threatening, cameras in both hands, getting arrested and then thrown in a dungeon. And I did another video about modern jails and dungeons, and I explained, showing with historical evidence, that there's really not much difference between the common ancient dungeons than there is with modern jails. And people say, oh, there's no torture. You trust me, there's torture. Happens all the time. If you haven't been to jail, and I have, then you don't know what you're talking about. It's torture. And some of the guards are corrupt, and they'll just let other inmates have their way with you. That's torture. And nonviolent people should not be in county jail, guys. At least they should be segregated. And so that's what Chille is focusing on right now, is his writings and research while he's locked up on segregating the jail system, so at least nonviolent people aren't thrown in a shark tank and getting hurt and harmed. Now, give me a bunch of ones for Chille, by the way, that you're rooting for him. And by the way, look, I am biased. I'm not going to sit there and say that I am. Oh, by the way, James Hill, thank you very much. 5 DLZ clips. I don't know if I thanked you already. So I don't know exactly, what's going on out there, other than there's just like this big feeding frenzy to go after this guy. And I'm not here to say, oh, he's the best guy, or what I'm here to say is, let him who is without sin cast the first stone. This is a very serious issue. This is your constitutional, unalienable rights. And there's a lot of people who should be on our side supporting overturning this conviction. But instead they have such hatred for the man that they're not looking at the bigger picture, which is this could be one of your people, one of your family members. And trust me, when you guys call me, I'm not going to say no. So at least you can count on me to be an honorable man and step up to the plate. If there's a way that I can help you, I'm going to. So let's get back into it, because we do have some time, at least an hour. So the public has an interest in the responsible exercise of the discretion granted by police and prosecutors. Prosecutors have pretty much absolute immunity. Can't really do much to them. And cops have qualified immunity. Pretty hard to break through that too. That's why we need to overturn Terry versus Ohio. Now, we need to ensure the public's right to gather information about their officials to uncover abuses. So I already went over that once before, but wanted to lay that out one more time. So this is like one of the main arguments, and it's a decent argument. So in line with these principles, in the Yokobuchi versus Bulter case, 193 F 3rd, it's also another First Circuit case. And I think that we heard, so I just want to really quick sort of like lay this out for you. So in law, we have state and federal, right? So we have state courts, we have federal courts. And I'm not going to like try to give you the biggest lawyerly explanation, all right? But because I want you guys to understand this at a human level. The federal courts are supposed to be limited to federal jurisdiction. Originally, it was Washington, D.C., 10 miles square, but the Supreme Court basically expanded it to where it became almost for anything. And so in any state, you're going to have federal circuits. And in California and Nevada, we have the Ninth Circuit. And the First Circuit is another jurisdiction, but it's still federal. So we're still good that it's federal, but it's likely not going to be mandatory authority for the Ninth Circuit to follow something from the First Circuit. And I think that that's what at least one appellate attorney was saying online the other day. Well, he's citing cases, there aren't in the right. Yeah, but guess what? When there aren't cases and they're not DPUBs, but they're valid law in another district, and there's a potential jurisdictional split, which there could be here if the Ninth Circuit goes against it. This is going up to the Supremes, the SCOTUS. So what will normally happen is if two federal districts disagree on something, or there's a misunderstanding, or they're not in accord, and what'll end up happening is it'll go up. So in this case, it was kind of genius, in my opinion, to use the Glik case, because if the Ninth Circuit basically overturns it, that could be an issue right there for the Supreme Court to want to look at, because there's an interest in comity in keeping the law as close as possible, especially in the federal districts, as you can. Now, in the state courts, it's similar. You have your appellate districts. I worked for one of the Court of Appeal in California. We call it Court of Appeal, not Court of Appeals. So that's one way you can tell the difference between a California state case and a California federal case, because the S at the end. So in the California Court of Appeal, you might have, the second district, the first district, the fourth district, and so on. And if there's a jurisdictional issue where you have two conflicting cases, maybe a car accident where one case says that you can run over a guy and not get convicted of a crime in this case, and another one says, no, that's a crime, that becomes a split, a jurisdictional split. And so that goes up to the California Supreme Court. However, if the California Supreme Court rules on something that might be deemed unconstitutional, you can directly appeal that, or even from a state case, you can directly appeal that into the federal circuits. And that's why I'm explaining this okay, or if you guys have questions before I move further. Let me see here. I'm just kind of taking a look. I just want to make sure that everybody sees what I'm saying and understands. Okay, thank you, Larry. Science and its math. Okay, I'm looking. Okay, thanks, guys. Thanks, SFV Copwatch. I appreciate it. Thanks, Gloria and Mikey B. You know, one of the things I got to say about Chille's audience, and since I've been allowed to come on as a guest once in a while, is you guys are super loyal, and I really have a lot of respect, and I appreciate you guys. And it really means a lot to me as a human being, being locked in an office all day, to see that there are still people out there who will be on your team DLZ. And I think that's super cool. And, you know, look, you guys all know he's not perfect, and I'm not perfect, and I'm not expecting him to be. This guy's putting his neck out all the time. And trust me, no amount of money in the world is worth going to jail. So the fact that he's willing to do this says a lot about him. And I'm going to get back into this now, because I don't want this to like be a big Chille love fest. But so basically, he was arrested, this Glik guy. Charges got dismissed. And then he did bring a 1983 suit, and that's basically civil rights case. And it was grounded largely in the Fourth Amendment, but did not include a Fourth Amendment claim. And that was noted. And they rejected the officer's appeal from a denial of qualified immunity. And basically, that was because the plaintiff's journalistic activities were peaceful and not performed in derogation of any law, and done in the exercise of his First Amendment rights. The officer lacked authority to stop him. So this is one of the issues that's been coming up is, well, the officer did say, well, you can record all you want, but you have to back up. So people are trying to say, well, that means that the officer said it was okay to film and Chille has no case. But we have to understand that police officers are trained to use pretextual arguments, because they basically have tailgate safety meetings where they talk about, when can I shoot a guy? When's it safe? Well, it's got to be within 21 feet. That's the kind of stuff they talk about. For example, when they're handcuffing someone and the guy is unconscious, they'll say, stop resisting, as they're punching him in the face. I'm not saying all police do this, but this is a very common thing that happens with law enforcement officers. They get this training because it's risk aversion, lawsuit avoidance. They realize that there might be people in earshot, or even people that are recording, but if they keep them far enough away and it's obscured by the camera because they're all huddled around this guy that they're beating and they're saying stop resisting, then they're good. And so I just wanted to give that some context for you guys, that of course he's going to say you can film, but we know that he doesn't want to be filmed. And in this case, BZ Watchdog was saying, it looks like he's hitting on that chick, and then he lets her go. Who knows? Maybe that was his girlfriend. Has anybody done any discovery or a public records request? I mean, nobody really knows anything about this mystery woman. I'd like to know more. Now, we know that the First Amendment protects the filming of government officials, but we know for years, especially in California, that law enforcement officers try to pull the same shenanigans where, oh, you're wiretapping, because they don't want to be filmed. And I know from when I was growing up, when we used to go out and try to do our audits with our big cameras, they would stomp on our cameras, beat us up, and throw us in torture cuffs, and they'd charge you with a 148. That was the standard operating procedure for anyone who refused to sign a traffic ticket. Pull you out of the car, beat the shit out of you, throw you in OCJ or Twin Towers. That was just the standard way you would do it. So let's get into this. So, and give me a bunch of ones if you guys know what I'm talking about. Trust me, I didn't just become a lawyer by mistake. It took a lot of beatings. by people who did not have my best interests in mind. Now, so basically in California, 148G, I believe. So it used to be 140. Everything is 148. Anytime a cop beats you up, they immediately charge you with resisting, obstructing, delaying. It's standard operating procedure, straight from the academy. So as a result, it was interesting. This is one cool thing about the California legislature. I think they made it 148G that says you have the right to film. So they literally put it right in the officer's bag of tricks that he would use to throw you in torture cuffs to say that, no, they have the right to film you. Now, in Nevada, you also have the right to film, but I don't believe it's codified. It may be. But either way, I believe that the U.S. Supreme Court has been very clear that you have the right to film police. Now, the way you do it is going to be the issue. And a lot of people here are saying, well, people who don't like Chille are saying, oh, he clearly interfered. And the guy's standing 10 feet away yelling at the cop. We know that words can't be used. I think it's the Wilson case that says that words can't be used to interfere or obstruct with a cop shouting from your front lawn. But here, since Chille was there at the scene, the argument that Nevada PD is using is that, well, it was 21 feet, within the 21 feet. And, it was dangerous, even though the cop said he wasn't dangerous. I mean, when you really look at the case, the DA should have never filed it, ever. This case, I worked for a prosecutor. The filing deputy, I guarantee you, would have never filed this case at the LA City Attorney's Office. No way. So anyways, if we go down the list here, there's a bunch of case law here. I'm going to get into the next arguments because I think I've kind of beat this one up a little bit. But basically, his attorneys cite Schnell versus City of, looks like Chino. That could probably Chicago because Seventh Circuit there. So we have a lot of cases. Unfortunately, they're not spot on in the Ninth Circuit. So naturally, his lawyer is going to cite the cases that are best on point that support Chille's case, which is exactly what I would have done. So don't think that it's unusual or improper to cite another circuit's case when there isn't any other mandatory or even persuasive authority on point in your circuit. It's very common. And that's how Supreme Court cases are made every day. So I don't think there was anything amateur about what his attorney did in doing that. I think it was the professional thing to do. And I believe that it's exactly what Alan Beck would have done. And I believe that Alan Beck is one of the best preeminent Second Amendment and First Amendment rights appellate attorneys in this country. And I know my appellate law pretty good, guys, and he is outstanding. Now, in our society, police officers are expected to endure significant burdens caused by the exercise of the First Amendment, and that's City of Houston versus Hill. That's a pretty solid case, and it's a U.S. Supreme Court case, guys. So the issue is going to be, was Chille being interfered with by the cop because he was filming, or was it because he was interfering with a traffic stop? Well, we know you can't interfere with a traffic stop by words alone. So clearly that would not have been the basis. The basis would have been, in Chille's case, the basis for this conviction, and you can disagree if you want. If you're a lawyer and you want to disagree, pipe in, put it in the sidebar. But the basis of this particular case was that the court apparently felt that Chille didn't respond to the officer's commands fast enough, because the officer is saying that he gave Chille a lawful command to back up. And we did see Chille back up at least 3 feet. We saw that the officer's testimony was not credible. Certainly not believable, in my opinion. I think on an abuse of discretion standard, the judge, being the jury here, should not have bought the officer's testimony. And if Chille's body cam footage would have been brought in, I think that this would have given her pause for thought. Now, oh, by the way, a little backtracking. In the brief, it does talk about Chille using the word PIG to the court's bailiff. And one of the problems I had with the brief, and this is no insult, it could just be an oversight, because I'm a stickler when it comes to this stuff, is that the officer, the bailiff, snatched Chille's phone out of his hand when Chille was trying to hand it to the prosecutor, which was, that was not a bad idea to do that. And instead, the bailiff intercepted and snatched that out of Chille's hand. That's called battery. In any other situation, that is a battery. When you snatch something out of someone's hand, that's a battery. That is a felony or a misdemeanor, depending on the state and the totality of the circumstances. So usually it's a wobbler. The DA has, or the city attorney has discretion on whether that's a misdemeanor or a felony, or to file it at all. But in this case, it is a courtroom, and courts have amazing power to control the courts. Now, I have done legal research on this, and I cannot find anything on or off point that would suggest that it was lawful or legal for the bailiff to snatch the phone out of Chille's hand. And so I believe that that was a battery. And so, not that that needed to be mentioned in the brief as such, but that fact is missing. And that is why Chille called the guy a pig, because the guy snatched the phone out of his hand and he was pissed, because Chille believes that he has just as much authority as anyone else in this world to speak his mind, no matter where he is. And in this case, he was offended and he spoke his mind, and the judge didn't like it. The judge threatened him with contempt, but ultimately did not find him in contempt. However, many people believe that she found him in contempt through sentencing. And give me a bunch of ones if that's what you think, because I think that's the biggest problem people have with this case. They feel that the court was unfair and that it would have been a better move for her to find him in contempt. I tend to be one of the people who thinks that he should have received a contempt warning. He should have been forced to apologize to the bailiff, and that should have been the end of it. But again, I digress. Let's get back into the brief. Now, the court summarized in Glik that it's not an unqualified right. A citizen's right to film government officials, including law enforcement, in the discharge of their duties is a basic and vital, well-established liberty safeguarded by the First Amendment. And accordingly, in the Glik case, they held that the district court did not err in denying qualified immunity to the cop. So again, this is a little bit different case, guys. This has to do with Glik wanting to sue the cops, and then the cop appealing because the cop lost his qualified immunity. And I believe that's what should happen here. I believe that the officer should lose his qualified immunity. I believe it was an unlawful arrest, and we probably won't know until it goes all the way up to the highest court. But the good news is with your support, at least Chille will have an opportunity to see that happen, because he's not the kind of guy that's going to give up. And so I believe if you're able to continue supporting him and his lawyer in particular, I think that we may make case law here, guys. You guys may make case law. And that's the issue. You don't see a lot of appeals or infractions go up on appeal. So you see people's rights getting violated all the effing time, guys. And so it's such an honor and a blessing to see that someone's finally fighting some of this stuff on the misdemeanor and infraction level. But again, it almost requires a nonprofit billion-dollar company to fund this, because it's impossible to take care of yourself while you're locked away. It just is. And that's one of the reasons why I've agreed pro bono to help him. I've agreed to come on sometimes and just support the channel and answer legal questions if I can. And that's why I'm here. So let's get into it some more. So we know that the cop lost his qualified immunity. And then here his lawyer is saying, well, basically, DeCastro said that he films cops. That's what he does. He was at least 10 feet away. It's constitutionally protected to do that. And, even if it was provocative or challenging, we know that. But he's saying that Officer Bork was unable to demonstrate restraint and came at Chille and found basically a pretextual reason to arrest Chille. And I think that's what we all think. And so the prosecutor asked the following question: did Chille obey those orders? And Bork answered, no, he did not. But we know from the videotape footage, from the officer's own footage, that Chille did obey the orders. It's just apparently the officer wasn't satisfied with the speed at which Chille was obeying the orders. Now, me personally, I don't believe that Chille had a duty to back up. Just like if a cop's beating the crap out of you and using excessive force, you have the right to defend yourself. The problem is they'll beat the crap out of you and throw you in prison while you're contesting those charges. And ultimately, you'll be exonerated with the right evidence that you had the right to fight off excessive force, just like you have the right not to obey an unlawful order. I believe it's Marbury versus Madison that says all laws which are repugnant to the Constitution are null and void. And I don't just mean laws with an uppercase L, policies and procedures. Those are all, administrative internal laws used by law enforcement. And giving someone an unjust command to back up while they're filming and there's no threat or danger to you is unjust. And again, the officer already admitted on the record that he knew that Chille posed no physical threat to him. So the whole argument used by the jury in this case to convict, as well as the officer and the prosecutorial team, was that Chille was apparently dangerous because he was within the 21-foot so-called danger zone that does not exist in law. Based upon a depublished Ninth Circuit case, by the way, that's the only place you're going to find the 21-foot rule is a depub Ninth Circuit case. It's kind of funny, right? So let's get into this. So we know that was false about the officer. We know that the body cam footage establishes that Chille backed up. The good news is that hopefully the appellate court will take a look at that and they'll see it for themselves. Because in this case, clearly the jury was not paying attention because Chille did obey the commands. The question is going to be, was he fast enough? Well, last time I checked, Chille's not in Marine boot camp. It's not do it now, move, right? So if the officer thinks that way, it's basically a question of interpretation. So now the difference here we have is, basically his lawyer is suggesting that the officer, presented knowingly false testimony. And he cites a Supreme Court case that says the failure of the prosecutor to correct the testimony, which he knew to be false, it violates the 14th Amendment. Now, okay, so here's one of the issues, guys. This is a problem with this case. And I agree with some of the detractors here. Chille's lawyer didn't make objections. Now me, I'm an objection machine, lacks foundation, compound, disjunctive, conjunctive, irrelevant, you name it, guys. I'm throwing them out there. From doing appellate law, all I do is make objections to the point where it's like, can you approach counsel? Because sometimes the judges don't like it, but I'm not going to stop because we don't stop, as Chille would say, because those objections are how you protect the record. Because I always assume that the so-called black-robed taskmaster is going to rule against me and assume that I'm not going to fight back and go up. And so I always approach it as if I am going to go up, because usually I'll have to if I get a tough judge. You can't 170.1 and 170.6 every judge you have. And I'm not saying that all judges are bad, but in a criminal case, I certainly don't want a hanging judge, and I certainly don't want a judge who is gonna let my personality affect their judgment. So let's get into this. So we know that's a potential issue, right? That's more like ineffective assistance of counsel. But I believe that the appellate court, under their review standards, in the interest of justice, may go ahead and consider these things. Now, and look, I may be totally off base, guys. Look, these opinions are like assholes, like I said before. Practicing law is an art; it's not a science. But we do know that the difference between our society and a totalitarian society is the basic freedoms of free speech and press. And of course, his lawyer is saying, admittedly, Mr. DeCastro would be harshly treated for this in Russia or China or Iran. And I agree with that. I mean, and that's the problem that I have is based upon what I'm seeing, this does not look like the America that I grew up in. Give me a bunch of ones if you think it looks more like the Soviet Union. Give me a bunch of twos if you think this is good. Hey, thanks, Art. RNR 9/11 News. The stop was over. It was never pointed out in court. Yeah, I see that, man. I see there's a lot of issues going on there. And, it just looks like ineffective assistance of counsel, and a lot of people say, well, Michael Meehan was dealing with a difficult client. But guess what, guys? If I was a Nevada lawyer and I had a client like that, who wanted to run the case, I wouldn't represent him. I'd sit him down and say, look, you hired me because I know better than you. And I'm not going to be your second stringer. I'm not going to be your second chair. I'm not going to take your money. Here it is. So ultimately, it boils down to the lawyer, and you can go for the money, or you can do what's honorable. And I'm not saying that he just went for the money here. It could just be that this guy just had a bad day. He looked like he was a deer in the headlights at the trial. So now, I agree with the appellate lawyer. The conviction is chilling to the protections guaranteed by the First Amendment. It definitely chills free speech, and definitely will cause the public to fear filming police, of course. And isn't that the idea? Isn't that what they want? Isn't that why they want to silence people they disagree with, or do political persecutions, go after people's businesses, go after their families, because they want to silence them? Because to them, the First Amendment is the enemy of the Leviathan. And the Leviathan is all they care about, because they're within that system. They're already getting a pension. They're getting everything from you through the tax base. They don't need you anymore. So why would they care? Now, everybody else, we're out there like entrepreneurs working 18 hours a day, trying to figure out a way to feed our families. They don't care about us, right? Give me a bunch of ones if you think that most government officials don't care about you. And that's a big problem. And give me a bunch of ones if you know that we're 75 trillion in debt, and that we're probably going to lose Social Security payments. What do they say, within the next 10 years? Something like that. I don't know. It's pretty dangerous, right? Give me a bunch of twos if you think the administrative state is wonderful and that they care about you. Now, let's get into this. So in this case, we had a conviction that definitely is going to make people be fearful of filming the police. I mean, you already see that. I mean, you don't really see that many auditor videos anymore, and then that are any good. And then we know that May 4th, our own Congress admitted that the FBI has been illegally spying on us and looking to see if we support, if we use keywords like sovereign citizen or First Amendment or Second Amendment or FJB. And if you use any of those words, you're deemed a potential domestic violent extremist. If you support legal immigration, you're a potential domestic violent extremist. If you shopped at Dick's Sporting Goods, or you like to shoot, you're a potential domestic violent extremist. And they did this in violation of the Fourth Amendment by forming a partnership with a private company so they could spy on all your bank data. So we know that that's what's going on. They're trying to silence people and classify people based on their political beliefs. And in this case, if you support the Second Amendment, clearly you're a right-wing extremist, because apparently Democrats no longer support the Second Amendment, I guess. I mean, give me a bunch of comments if you can understand what's going on here, because all my family members who were Democrats were all shooters and they supported the Second Amendment. I don't know what's going on. So in this case, the insulted officer apparently was highly sensitive and stated that Mr. DeCastro refused to back up, and he refused to stop filming. He did say that on the record. So we do have evidence that the officer wanted Chille to stop filming. And the officer also claimed that he couldn't carry out his duties because of officer safety, but we know that the stop was over. So that doesn't make any sense. And then in finding Mr. DeCastro guilty, the trial court decided the safety of the officer and the driver. And I remember that. I saw that. And I don't think that was sound reasoning. I don't think you guys do either. Now, and again, I think he was correct to say that the bystanders in the Floyd case could be accused of interfering with the officer's safety. Absolutely. I mean, so, I get it. Nobody died here, but, that's kind of splitting hairs. A lot of people like to split hairs. They were within 10 feet. They were filming. None of those guys got arrested, and they were screaming and yelling at the cops also, just like Chille was. So I think it is a good comparison. So look, I'm going to be critical where I think I need to be critical, and I'm not going to be critical, and I'm going to be supportive when I need to be supportive. And although I'm biased towards Chille's position, I do believe, from an honest point of view, that these are solid arguments, guys. I think that Orem did a good job here with these comparisons. And I think it's really hard when you don't have a strong body of law yet. And I think that Orem is creating a body of law. Okay, that's something that I want to point out. There's not a lot of law out there like this, because this is a recent phenomenon of people getting brave enough to film police, And of course, before they would stomp on your camera and you would get charged and you would get, be convicted. And so you would, because that's the goal. They want to convict you, right? Because that way they silence you. Because you're a political enemy. They want to get as many convictions against you to show all your political opponents and your supporters that you're a criminal. And that's what they, did in the Soviet Union. That's what they do in China. And that's what they do in Canada with their social credit scoring system. If you don't agree with Trudeau or whatever, mini Castro, then, you need to have your social credit score reduced and be denied the right to travel or get money out of your bank account. People are starting to catch on. Give me a bunch of ones if you guys are starting to catch on. I'd like to see a bunch of ones. So really quick, we'll just get down the list here. So Mr. DeCastro does have a right to film public officials, no doubt about it. And he has a right to do it in a provocative and challenging manner. And the court in Glik held that that was a violation of Glik's Fourth Amendment rights to get arrested for doing that. And pursuant to that case law and the Supreme Court, DeCastro had a right to film the cops, and that's what he did. Now, so they have several arguments. That's something that I want to point out. I do think that's a pretty good argument. I really do. I still think he's got a stronger argument with ineffective assistance, and I'm not trying to slander or say anything bad about his trial lawyer, because I think he really got stuck with a tough client. Yeah, I mean, come on, guys, let's face it, Chille's going to be a tough client. He's very set in his ways. And I think that lawyer had a tough time. So I'm not holding a grudge or saying anything bad about him. I just think that in this case, me personally, I would have either walked away or had a sit down with my client, because he didn't look like he was prepared to me. And he didn't look like he had filed the necessary briefs in objection. And I don't feel like there were any objections made. And that's a problem, because those objections could have easily created a phenomenal record on appeal, and may have, in fact, stopped the lower court from issuing such a harsh sentence. So that's something I also have to understand, is that judges don't like getting reversed. And if you're a good trial lawyer, you're going to make the right objections, and the judge is going to see, oh man, this guy's sharp, so let's give him the low end, right? Even if the guy's a jerk. And honestly, I like representing the guys that people don't like, because those are the ones who need my help the most. And I hope you guys understand what I'm saying, because they're just as entitled as you. And I will never sit by and see someone punished wrongly just because they don't get along with other people. It's not going to happen. That's not what the Constitution is about. It's about being who you are. So looks like argument 2 is the second count. The second argument is count 1 must be dismissed because the laws are vague and ambiguous. And that is the obstructing a peace officer law. And this is a really good argument. I really like this argument. And it basically is I'm just going to nutshell this one for you guys. Basically, in a nutshell, what it's saying is that it's basically saying that this gives the cops unfettered discretion to say anything as obstruction. And that's what they were doing in California with 148. Oh, this guy looked at me the wrong way, I'm going to hit him with obstructing. And that's really what this is about, in my opinion. By the way, I'm going to have to wrap this up pretty soon, because I've got another show on my channel coming up at 5:30. But basically, that's what they're saying in this brief, is that argument 2 is that the laws are just super vague, unconstitutionally vague, to where it invites arbitrary enforcement, and it leaves judges and jurors free to decide without any legally fixed standards. And I think that is absolutely true. I mean, I think that is a really good argument. Now, again, the problem again is that I don't recall anything on the record where the trial attorney made those objections. And that's terrifying for me, because that would have been the first objection that I would have made as the trial lawyer. And I would have had written objections in California anyways, in the form of a brief objecting to all of this stuff. I would have filed motions to dismiss, 1538.5s, you name it. I would have been going balls out to get this case blown out. I would have been having meetings with the filing deputy, trying to not get the file, not trying to get it not get filed. I would have tried to explain to the filing debt, because sometimes, so what's going to happen is the cop issues a notice to appear, you get a summons, that goes to the DA, they get a jacket, they open it up, and they decide whether or not they want to file charges. And if they don't, it's called a DA reject. And that's what I would have been pushing for, is to make this a DA reject. So that's the issue that I have, is without objections being made on the record. And look, if you're an appellate lawyer, federal, especially, pipe in, man, put it in the comments, because I'm by no way, shape, or form trying to say that I'm an expert federal appellate lawyer. My experience in federal is nowhere near as strong as it is in California state appellate law. And so it's different. Now, basically, this is a vague statute. So assuming that the appellate court agrees that it's vague and in the absence of objections allows these arguments, I believe that these statutes are vague and ambiguous from a constitutional perspective, because it allows the court or a cop unfettered discretion to decide what obstruction is, what interfering is. And so because it fails to provide sufficient notice to enable persons of ordinary intelligence to understand. And look, you'll recall, as Chille was asking the officer, what will that look like? He's trying to get instructions. The cop's telling him to do stuff. And Chille's going, what would that look like? Because Chille is trained. He may not be, a 20-year lawyer. He didn't go to law school. He didn't go on the law study program. But I'd say he's done a pretty fair job of educating himself. I'm not going to take that from him. And he was asking the cop, what would that look like? What do you want me to do? So he was trying to understand. That shows me a state of confusion, which is unusual, by the way, for Chille, because usually he's pretty stalwart and he's pretty much going to stand his ground. And in this case, it's almost like he kind of knew that he needed to, maybe he did some additional research and realized that he needed to do that. Now, in this case, the laws lack specific standards, and that thereby encourages and authorizes and fails to prevent arbitrary and discriminatory enforcement. And that's the problem with a lot of laws, guys. Is a vague and ambiguous law is really not even a law, because there's no way how to abide by that law. And from a constitutional perspective, I agree. I mean, they've got these catch-all laws that make it easy for cops to throw you in the jail. And, you're screwed once you're in there, guys. I mean, if you don't plead out right away, you're going to be paying a lot for a lawyer. No one can afford that. And the system knows that. And that's how they employ all those people and give them jobs. And I just think it's dastardly, and we need to change the system. So anyways, they lack specific standards, and I agree with that. And then he goes into the different prongs of the standards. He gets into the application of law by the state, and the second prong. I encourage all of you guys to read his brief. If you don't have his brief, reach out to BZ Watchdog. I'm sure he's got a copy of it, or he can get you one. This guy's a genius. But basically, these are like standardless laws, because they authorize and encourage seriously discriminatory enforcement. Now, let's get into this, because we're going to end this thing and get into discussion. And yes, it's vague and ambiguous. The obstruction laws are vague and ambiguous. We know that. Give me a bunch of twos if you think these make sense. And then it also says he was denied his rights because the judge had prejudice against him and bias in favor. To me, that's a side argument. Probably should have been at the very bottom in a footnote. I don't think that is going to get you any love from anybody. Gets into implied bias. I mean, look, I'm going to call him like I see him. That one I don't feel that's a strong one, unless we can prove, and this is something I don't know. There was, so strike that. If we can show that she has a systematic pattern of enforcing a particular statute in a certain way, and in this case, she varied, that might be persuasive evidence, but I don't know enough about Nevada law or the federal standard on that. So I roll that back a little bit. If it can be shown that there's a way to prove bias, then yes. But as a general rule, a trial court's decisions are going to be presumed unbiased. And that's just going with the territory, guys. So don't hold it against me, because I'm basing my opinion on a legal system that basically treats judges as untouchables. And so we have to understand that when we're filing an appeal, in my opinion. So, and also remember, the people who are looking at this case used to be at her job, probably. So they're part of the same group of people, and they don't want the judiciary to look bad. They don't want to bring discredit upon their institution. Now, in this case, a judge's failure to disqualify themselves is an abuse of discretion. We know that. I'm just trying to find the evidence of judicial bias here. So there's a standard of review on actual bias, and correctly, his attorney is saying it's plausible that DeCastro demonstrated bias. So, look, this guy's no dummy. All right. When you actually read his brief, I mean, I'm liking this guy more and more. I think his appellate lawyer actually did a pretty good job. And I don't want you guys to think that he didn't, and get a second opinion from someone who's not a YouTube lawyer, like talk to some lawyer outside of YouTube. I just started doing these videos a couple months ago. This is not what I normally do, but I just feel compelled because there's so much hatred for this guy, and nobody's looking at the issues that are being presented, which is government overreach and the administrative state Leviathan. At least that's how I look at it. And to me, that's what we need to focus on. If you have children, you can appreciate that better, I think. That's why I think everybody should have several kids, have as many kids as you can, because that will change everything for you in a positive way. Now, this is the argument that I believe is probably his best argument, and I'm not in any way, shape, or form throwing this other attorney under the bus. I'm just looking at this from being someone who's been an appellate lawyer for a long time, and someone who profusely objects almost with every other word to preserve the record, that I didn't see any objections, and I saw a lack of confidence in the demeanor of trial counsel. And I think that he was well-intentioned. And again, I'm not a Nevada lawyer, so I'm not going to try to speak out about anything that he did procedurally that I'm unaware of that the law did or did not require. My issues with Chille are limited to things that I do out of state and things of that nature that I'm not at liberty to discuss. But I can tell you that as a lawyer with a lot of experience in appellate law, that I don't feel that proper objections were made. And give me a bunch of ones if you guys think that, and give me a bunch of twos if you guys can show me some objections. I don't think I saw a single objection in this case. And so there is a standard of review for ineffective assistance of counsel that is sufficient to invalidate a judgment for a conviction. And that's if the counsel's performance fell below an objective standard and the counsel's errors were so severe that they rendered the verdict unreliable. And I do believe that that is the case here. I do absolutely believe that. We know that apparently there was a brief arguing constitutional issues that the judge wouldn't hear because it wasn't timely filed. Now, we can blame Chille for that, of course, but he's not the lawyer. And so it's the lawyer's job to make sure that that gets done. And so let's just keep going. I'm trying to get you through this quickly, privates. Now, we know here that the result of the trial, I think, would have been different if a lot of things would have been done differently, including bringing in Chille's body cam footage. And that didn't happen here. And I don't know why. It just doesn't make any sense to me, because I believe that his body cam footage was exculpatory. And I don't know what other constitutional arguments that were made in that brief were, because we never saw the brief. Now, we're just going to keep on scrolling. This bad chicken, as Chille would say. Give me a bunch of OTVOs also while we're doing this. So I want to wake you guys up. Give me a bunch of OTVOs. Give me a bunch of FCs for free Chille. Let's get him out of there. He doesn't belong there. Now, there's an established standard to determine ineffective assistance of counsel, and that's all here in the brief. You got to get a copy of it if you want to read the rest. Reasonably effective assistance standard articulated in Strickland. It's also mentioned in there to show deficient assistance, and that the deficiency prejudiced the client. So even if it's deficient, that should be sufficient. Now, there's a prejudice requirement in ineffective assistance, and here I think he can argue that he was prejudiced. by not being able to present his case properly. And then it is argued here that his lawyer failed to file the proper pretrial motions to dismiss, which due to violations of freedom of speech and freedom of the press. So if that's the case, and the upper court buys into these arguments that it's ineffective assistance, I believe they can go back and take a fresh look at all these other things. And so I think this is probably a good argument. Now, whether or not Chille wins, who knows? It's so based on who your judges are, who the panel is. It's just a crapshoot. But I do believe that he has valid, sound arguments, and I don't think that he's out of the race. And even if he lost this appeal, which he could, I believe that Chille has the balls to go all the way to the Supreme Court. And my hat's off to him. Having visited him in jail, I see that he is resolute. He is still driven. He's positive. He's upbeat. And I have a lot of respect for those qualities. And I also will say this, that the jailers were kind and courteous to me. The whole time that I saw them with Chille, I feel that they were highly respectful, and I thought that they were courteous and considerate. And I felt that the staff at the jail itself were courteous and considerate. And I really want the best for Chille, and I hope that he comes out of this a better man. And I hope that you guys do too, even the people that don't like him. I think that anybody aside, I think with few exceptions, that everybody deserves an opportunity to not have stones cast at them for things that we're all guilty or potentially guilty of. And let me just go through this really quick and try and take a look at this to see if I'm missing anything. It looks like he's arguing that, the Sixth Amendment right to effective counsel was denied here. And, and I kind of do feel bad for the trial lawyer, because I know that this is a tough client, not from my own personal experience, but from seeing this guy just out in the real world. He's a tough dude. He is demanding. And I know that's a tough deal. So please don't hold it against him. I think that you guys should give his trial counsel a bunch of ones for having the balls to even represent Chille, because that is a tough guy. And I think that it took a lot for him to step up to do that. And I think that he is a great lawyer. And I think aside from this particular case, I think mistakes were made. And I don't want to make up excuses for him, but looking at the totality of the circumstances, I think that you guys should give the guy a break. And I think that Chille has given him a break. So that's why I take that liberty, because I've heard Chille say it on his own live streams and videos or whatever, that he likes Mike. And, I think Chille kind of admitted that he's a tough client. So, just give him some ones, give him some respect. This is not, being a lawyer is not an easy job. Most people hate us already, including our wives, because we're always working and the kids don't get enough dad time. And that's something I get yelled at a lot about since I've been doing these videos, because I didn't normally do this. I just, worked, which I think she likes me doing better. But I like doing this and I like helping people. So this is good for me. So anyways, the argument is that, he received ineffective assistance of counsel. And that's, although it's the last argument, and there's other arguments about vague and ambiguous and First Amendment. Look, I think there might be a chance here, guys. There might be. And now in this case, I know he filed a brief to add more pages. Typically, that's something that I don't do, but I would imagine that his client had a lot that he wanted to say. And so that's one of those things. But just remember, KISS is the word. Keep it simple, stupid. The longer your brief is, the less likely the court is to read it. And so now, procedurally, here's what's going to happen. And then I'm going to have to bone out of here. Procedurally, here's what's going to happen is an opposition brief on appeal will be filed, typically by the prosecutor or the DA, And then Chille's counsel will have an opportunity to file a reply brief. And so typically the opposition is going to be a little bit less or the same page length as the appellate brief. And then the reply brief, it will be much smaller, like either 10 or 5 pages. I don't know what the standard is right now for the Ninth Circuit. Just haven't got there. But if you know what it is, guys, if there's any lawyers in here, throw it in the sidebar. I'd love to see it. And hey, thanks, Brick. I mean, I know I'm not Chille with the super everything that he's got. I don't have that dynamic personality. I'm more of a humble guy. But, you know, I'm not saying he's not humble, but you know what I mean? I don't have that dynamic personality where I suck all the oxygen out of a room when I walk in. That's just a natural thing that he's got going for him that I don't have. But I do my best with the tools that God gave me. How's that sound? So anyways, I hope that you guys all got an opportunity to learn a little bit about, you know, the difference between federal and state laws, jurisdictional differences, the differences of, you know, split opinions, split decisions, jurisdictional splits between different courts and state and federal, right? And how it goes. And you learned a little bit about what us lawyers have to go through. And I hope you learned a little bit about, you know, laws, vague and ambiguous laws, how some laws give cops a pretext to be able to falsely arrest you. And guys, if you don't have money for a lawyer, you're going to get a conviction. That's just how it is. And why I think it's so important that we film the police and that we have absolute just openness when it comes to law enforcement, and that we should elect representatives not based on what they promise to do, but what they promise not to do. I think we should elect people based upon the laws they delete, on deleting laws rather than the laws they pass. I think that that's what we should focus on. That should be our goal, is getting rid of laws instead of passing more, because less government is more freedom. And that's what natural law, the constitutional republic, and the Bill of Rights is all about. That's why I joined the Marine Corps, to fight for that. Look up Smedley Butler sometime. Smedley Butler. Google him sometime. He was a very famous Marine who talked about the Great Leviathan and about how politicians are paid off by these mega corporations in endless wars. And he was a Marine, just, you know, I'm nothing compared to Smedley Butler. Just Google him sometime and you'll know what I'm talking about. Look up some of the books that he wrote. Just do that for me. And by the way, oh gosh, thanks, Dr. Cheng. I appreciate that. Dr. Cheng says you're doing a great job, buddy. Thank you. So look, I'm going to just go through the list in the sidebar, because I always know about the audience thing, because I'm one of these guys who used to go into these chats all the time. And I always loved it when the guy who was the host would talk to me like, oh, this guy's talking to me. That's cool. So not that I'm saying I'm anything special, because I'm not. Well, to my kids and my wife, I am. To them, I'm a hero. But to you guys, you don't know me from Adam. So I'm just going to tell you, thank you, RN 911 News, for coming. And by the way, thanks everybody if you gave super chats. I didn't see everything on the screen. Thanks, Brian Hajdari. Thanks, Gloria, for always coming. I really appreciate that. Thanks, Martin. Michael Martin, for the tree chili. And get a beer with that. Thanks, Jill V. Thanks, What's the Matter You? What's the matter you? Hey, gotta know respect. Hey. I'm sure I'll see that on Dick Bag Patrol tonight. Him going, Michael Eline said, what's the matter you? Hey. Well, it gives him something to do till Chille gets out, right, guys? So a membership, yes. Hey, Truth of God. Good seeing you, Truth of God. I love that. And Claudette, thanks for showing up. Thanks, Anthony Pisano. Thank you for showing up, my friend. I really appreciate it. Thanks, MCW. Free Chille. I agree. Let's get him out of there. And let's look here. Tater Girl, thanks for showing up. Toby Barrier and Let's OTVO, as always. By the way, everybody, I had an opportunity to meet Let's OTVO at the courthouse when I originally went there is a potential witness to verify that the recommendation letter I attached to his brief was true and correct, because it was unsigned. And I met Let's OTVO there, and he flew all the way out to Nevada for Chille. And that's what I'm trying to talk about, guys. love him or hate him, he's a dynamic guy. And somebody like that does have the power to move mountains. And if I believe with proper legal training and some mentoring, I believe that he could make a great lawyer. I really do believe that. And I have faith. And I have faith in you guys too. And I believe if you've made mistakes in your past, like I have, that you can move forward and become a better person from those mistakes. Even if you just feel like dog shit, like, sometimes I feel like I could have been a better son, before my dad passed away, but you got to move forward, So Marcus Aurelius, I love it. Truth of God. Dr. Chang, thanks for coming out. Michael Martin, balls. That's right. I think I know who you're talking about. And then, Marcus Aurelius. And Marcus Aurelius, man, what a great philosopher he was. And if you ever get a chance just to look at some of his quotes, man, what a dynamic dude. I mean, there's so many things you can learn from the ancients. And I highly recommend that you familiarize yourself with classical education and away from this government nonsense where they just make you into drones. So thank you, Dirty Dina, Dan691. Yes, KT, as always, thanks. Thomas Rockholt, thanks for coming. Jilly V, Kurt Bronson, Wanda Mise, everybody, thank you, thank you. Complying Board, thank you. Everybody, thanks for supporting the channel and keeping it alive while Chille's locked up. That really is something that you guys are actually helping the channel grow in numbers while Chille's locked up. And I know it's becoming kind of a variety show, but hey, this is cool. At least the channel's still up. And man, his editors probably have 2 years worth of footage they could edit where Chille's been out there doing audits, like the real good stuff from before everyone was terrified because of what happened in Chille, right? Can you see how what happened to Chille has chilled First Amendment auditors and it's terrified people from filming the police? Exactly what many would say they wanted. Think about that, guys. Just think about that deeply. Be careful what you wish for, you other people who say that you support the First Amendment and auditors and stuff, when you're so vehemently against Chille that you can't see the forest through the trees. It's very dangerous what you're doing. Now, let me just get in here. Special K, thank you. Happy Cow, thank you, everybody. So now, everybody, I have another show coming up at 5:30 on the Michael Eline channel. I got this young talent. His name's Max Bonilla, and he's an auditor, but he audits Governor Newsom. He follows him around with a camera because he's really upset that Newsom is allowing the public schools to secretly transition kids without telling their parents, which is totally a violation of the parents' rights. And a lot of these kids are transitioning secretly, getting on hormone replacement therapy, and it's destroying their endocrine systems. And Max is this young guy who's standing up to the administrative state and the Leviathan, fighting against all this stuff. Man, thanks for whoever gave that super chat. Let me see who that was. Give him proper. I just saw it pop up. Hold on. Thanks, Chuck P, for supporting Chille. I really appreciate that. And let me just see. Now, guys, that's what I'm going to do. I'm going to put this up. So we've been doing a fundraiser for him, and I'm going to put it in the sidebar for y'all. And I'm also going to throw it up on the, I'm going to share this bad chicken. So we've been doing a fundraiser. I've been trying to help him. He's saying that this money here, that's the $2,295, will be used to help fund the second case that he has, which is for the crime scene tape case. We're still trying to find a criminal defense attorney. And as you know, it takes a brave criminal defense attorney to come and help Chille, because Chille's going to need a guy who's just as tough as him or tougher in order to form that spiritual energy that he'll need to feel secure that this lawyer is going to be able to represent him. In my opinion, Chille is a lot like a street fighter. He wants to make sure that whoever he's studying under is better than him. Give me a bunch of ones if you think that way, because that's kind of how I think. Being a judo guy, I want to compete against black belts who are better than me. Now, that being said, we've so far been able to raise like $2,200 for him. which isn't really that much, but it's better than a poke in the eye with a sharp stick. And I really do appreciate y'all doing that. Now, tonight on my show, I'm going to have Max Bonilla come on. His handle is Outraged Teen. So I do encourage you to, if you don't see the show tonight, to at least check out his channel. Young 19-year-old guy and a total genius. I think he's got a super fast processing speed. He cranks out content like crazy, and he's going after the California administrative state system. Thanks again, Chuck. Free Chille. That's right. And yeah, I mean, Marcus, I do think that, you know, and look, I don't put any money in his GoFundMe, and he's tried to pay me in the past and I've refused. And but I don't, you know, I just am trying to donate my time. And I do appreciate if you guys see fit and you think that his cause is just, to do what you feel is just and moral. And I believe that Chille will be honorable in the use of your funds. And I'm sure that he would welcome an accounting to show you how the funds were used. And that's all I have to say about that. And there's nothing underhanded in me wanting to try and help him. Just understand that as well. Now, again, I have a show at 5:30 on the at Michael Eline channel with Max. I really would like it if you would come and support Max, at least if you're watching the channel right now, just because he's such a cool dude. He's 19, man, and he's just a cool guy. And he thinks a lot like us, like pro-America, USA, supports the Constitution. He understands what happened at Jekyll Island, fiat currency system, totally not brainwashed by the public school system, totally a free thinker. And I just think that you guys should come and support him, because I believe that he'll be the next generation of Chilles. But in this case, with my help, a young guy like this could have a law license, and he could be taking names in court, and he could be building a reputation for himself that can't be trampled upon by detractors, or is easily trampled upon by detractors. And so that's what I would like to see happen. And with that being said, please make sure to like and subscribe, and make sure to save this, because you never know when the thought police are going to take down Chille's channel. And they might, you never know, especially now that I'm here, because I'm definitely not somebody the thought police likes at all. And I do appreciate everybody showing up and all the super chats and all that. And I also want you to make sure to like and subscribe to BZ Watchdog, because Basil has been helping me a lot with legal research and doing audits and standing tall for Team DLZ. He deserves your likes and subscriptions, because he is a real auditor, and he's got some really cool videos that he's been doing on his own. And he's just struggling out there trying to make it happen as an auditor. And I really respect that. And then also make sure to like and subscribe to, here's the deal, to Brian's channel, because Brian's donating time to his channel, also to this channel when he has his own channel. And I think that's what he does for his regular gig. And every time you give a super chat to Chille, that's awesome. But, you know, that's something Brian could be getting on his channel. I hope that makes sense. Not detracting from anyone. I'm just saying, make sure to support him, like, subscribe, and share Brian's stuff to show your love for him, because nobody else has stepped up for Chille in the way that he has. And I think that this channel would be dying if it wasn't for Brian. I'm not giving myself any credit. I know I can't pull in 500 viewers like Brian can, but hopefully you've learned a lot from me. So make sure to like and subscribe, make sure to save, and make sure to join me on my channel at Michael Eline at 5:30 if you want to learn a little bit about Max Bonilla. And the issue is going to be about apparently a secret rule or something. We're going to find out tonight that Bill Clinton actually executed, that allowed illegal aliens to vote back then, that we weren't even told about. And just how amazing it is that the way the government hides things from we the people. And so I just love it that he does this research, and I'm hoping that you'll come and join me and take a look. All right, Semper Fi, do or die.